Good. Well, thank you very much, Dean and Vice-Deans. I think the rector has left, but I'm very honored to be here, and thank you for the invitation. I am going to speak about a small area of law, the intersection of law and forensic psychiatry. But I think it's symbolic of some very important questions, in particular some of the questions about the rule of law and the role of law in helping to shape the moral fiber of a society. Now, we all understand the importance of the rule of law. It's the foundation of prosperity, but much more important, the rule of law is the foundation of a just society. As a foundation for prosperity, the rule of law gives us predictability, integrity, and efficiency. But as a foundation for the just society, the rule of law most centrally functions as a limit on the state's exercise of its awesome power to deprive individuals of their liberty. I want to focus on a small but important part of that field, the intersection of law and psychiatry. And I'll give you just a little history. As Professor Szymanski mentioned, my background is as a lawyer, and as a lawyer, I have worked on behalf of people with mental illnesses for about 4 decades. So I come at this with some experience in working with people with disabilities. So here's my main thesis. The intersection of law and psychiatry are aspects that are key to human liberty. If that intersection, this area between law and psychiatry, escapes from the rule of law, then key areas of what it means to be a human being are also beyond the rule of law. And I'll just depart from my text for a moment to say that in doing a little bit of research for this, I was reminded of the role of Soviet psychiatry in the Soviet Union and the sad history of abuses that we all know about from that era. But it's not limited to Soviet psychiatry. American psychiatry and mental health law has a long history of abuse of people with mental illness. And so my thesis today is about the role and duty of judges to assert rule of law control in the area of forensic psychiatry. This is not easy to do. So let's look for a moment at the areas in which law and psychiatry interact. Some very key areas here. And I hope you also forgive me, of course, I look at this from an American perspective, but I think that most of these are universal in the law. So we often turn to psychiatrists in the criminal law to make a determination of criminal responsibility. Is the defendant able to know right from wrong? Is the defendant able to control her actions? Most societies and most laws have the idea of civil commitment or involuntary hospitalization for people with severe mental illnesses. I think the law also understands the concept of competence, the idea that in order to make a contract or to vote or to marry or to consent to medical treatment, an individual must have mental competence. Increasingly in American law and throughout other areas of the world, we're seeing a greater reliance in the law on the idea of risk, of predicting future dangerousness, and of intervening based on risk. This is another area that has made use of mental health professionals. Basically, law and psychiatry interact at a key area involving liberty and civic personhood. because to be full participants in the law in a democratic society, we expect individual peoples to be able to exercise responsibility and take responsibility and be responsible. And that, in essence, is what we mean by a person with civic wholeness. And this is an area then that is in the middle, in the space between psychiatry and law. So psychiatrists are involved in important decisions about individual liberty, about imprisonment, confinement, the exercise of personhood. Psychiatrists are involved in making key decisions about what it means to qualify as a person entitled to full participation in civic society. And it's for these reasons that psychiatry, that these decisions have to be governed by law. But there's a strong temptation on the part of the law and judges to delegate these decisions to psychiatrists. Courts ask for expert opinions about whether an individual can judge right from wrong, can control her behavior, has the capacity to consent, or is dangerous. And these decisions, these judgments, appear to us in the law to be psychiatric or medical concepts. And so we often, as lawyers or as judges, throw up our hands and say to the doctor, "Doctor, you please tell us, is this person sane or insane? Sound mind or unsound mind? Dangerous or safe?" But we know that all of these concepts must have legal components. They must be normative concepts. They express the values of our society, of what it means to be a person who can act with moral responsibility. But these are complex concepts. They mix law and psychiatry. They are at the intersection of two complicated fields. And so there's a strong temptation, as I said, by judges to delegate, to ask the entire question of the expert, and to accept the answers and opinions that are opaque, that hide the legal standards that are in operation. Some simple examples. How does one determine whether a criminal defendant was unable to refrain from his criminal actions or simply unwilling to? What kind of mental disorders in the big book that psychiatrists use qualify one for a determination of unsound mind? How severe must a mental illness be in order to justify placement in an institution? We could go on and on. All of these are mixed questions of law and psychiatry. So my thesis is that there are key problems here. We have an interaction of two complex systems. We have a problem of translating one set of expert concepts into another set of expert concepts. And all of this too often results in a delegation of the entire decision to psychiatrists. To take one more simple example, risk assessment, translation and calibration. The doctor says, this man is high risk. The judge hears the word high risk, understands that the law requires a finding of high risk, and accepts that judgment without any question. We don't know whether the psychiatrist and the judge are speaking the same language, even though they are all speaking Lithuanian or English. So I want to relate this very briefly to the key obligations of a judge. I think these are probably universal, but here are several of the obligations that the European Court of Human Rights has identified on the part of judges: independence, impartiality, integrity, diligence, and competence. So let's take a look at these in turn. Sorry. Impartiality. Judges have biases. Delegation to judges impairs the concept of impartiality. Judges have an obligation to ensure that decisions are impartial. And when they delegate these decisions to psychiatrists, they give up that obligation. Independence. It is the judge who must be the spokesperson for the rule of law. And when judges ask psychiatrists who are neither trained in law nor authorized to apply law, they give up their independence. Integrity. The application of law to fact is a judicial function. When judges abdicate that function and adopt opaque psychiatric opinions without examining the important normative judgments inherent in them, the duty of integrity is compromised. Finally, and I think this is perhaps the most important one, diligence and competence. Understanding the intersection of law and psychiatry is not easy. As I said, it involves two complicated expert areas, and it also speaks to some of the most fundamental questions of the law, and that is, what does it mean to be a person in the law? And it will take hard work and learning on the part of judges, lawyers, and psychiatrists to ensure that these important kinds of decisions are made in a way that is fully under the control of the law, which, as we hope, is a law that belongs to the people and not simply the experts. So I want to end by just introducing, if I might take a minute to introduce people to our institution, William Mitchell College of Law. And I feel like it's St. Paul, Minnesota, northern climate, very, very similar. The trees in Minnesota are turning colors right now, as well as here in Kaunas. So I feel very much at home. It's a Midwestern city. And while you are celebrating your 90th anniversary, we are celebrating our 110th anniversary at William Mitchell as the law school. We are a practical law school. We've been teaching lawyers for 112 years. And two of our professors have already been honored to be here at VDU. Jay Ersling, who's in the picture here, was here, and Ken Port, both intellectual property lawyers. We have a LLM program for law graduates from other countries. And again, once again, I would want to thank my hosts for inviting me, and hope that we can have a long and fruitful cooperation between our law schools. Thank you.